Good morning. The House State Affairs Committee will come to order. At this time, I'd ask the Secretary to call the roll.
Representatives Anderson.
Here.
Beal.
Here.
Chafee.
Here.
Goodwin.
Here.
Gosh.
Here.
Hanson.
Here.
Jensen.
Here.
Lesmeister.
Here.
Reimer excused. Smith.
Here.
Weezy.
Here.
Johnson.
Here.
Peterson.
Here.
We have a quorum, Mr.
Thank you,
Chairman.
Madam Secretary. First up is House Bill 1073. Provide for diploma privilege for admittance to the practice of law. Open for proponent testimony.
Representative Mary Fitzgerald, District 31. It's an honor to be before you today. A state representative has an important job. We are the voice of the people of the state of South Dakota. The South Dakota legislature, to me, is the most important branch of government. We represent the people of our great state of South Dakota. It is our duty, it is our obligation to listen to our constituents and assure them that their voices will be heard. And that is why I am here today. House Bill 1073 is an act to provide the diploma privilege for admittance into this practice of law. I just want my fellow lawmakers to know that this is not something new, that this actually existed in the state of South Dakota for nearly 70 years. In 1903, the state legislature enacted the diploma privilege, and it served the state of South Dakota well. The diploma privilege was enacted to encourage the academic study of law, and more importantly, to keep native South Dakotans in South Dakota. I sit in appropriations every day, and I hear all the time about the brain drain going on in South Dakota. This current bar exam has contributed to young people leaving the state. I'm going to cut my testimony short due to the 30 minutes, and I would just ask all my fellow legislators to please listen to the testimony and remember that we are here to represent the state and our constituents. Thank you.
Thank you very much. Further proponent testimony for House Bill 1073.
Good morning. My name is Roger Barron, and I'm here on behalf of House Bill 1073. I do have a handout that I've asked one of the pages to distribute. For the committee members, I'm hoping that you get one that has yellow highlighting on it. Not all of those have that, but I'm hoping that. I'm from Missouri, born and raised in Missouri. My undergraduate degree is a Bachelor of Science in Secondary Education with a certification in mathematics. I graduated from the University of Missouri at Columbia, or Mizzou, with that Bachelor of Science, and then I attended law school at the Mizzou Law School, graduated from the Mizzou Law School in 1976. I practiced law in Missouri for 9 years, and then I began my teaching career as a law professor. My first job was in Houston, Texas. I taught at South Texas College of Law in Houston for 5 years. And then in 1990, my wife and family, we moved to Vermillion, South Dakota, where I began teaching at the University of South Dakota Law School. I taught at the law school there for 25 years. My course assignments were Civil Procedure 1, Civil Procedure 2, Insurance, and Family Law. I taught every semester. I took no sabbaticals. I retired from full-time teaching in 2015, at which time President James Abbott designated me as Professor Emeritus upon the recommendation of Dean Tom Gouey. I continue to remain affiliated with the law school. I run a listserv through the law school, through the university, that serves lawyers and judges in South Dakota. There's approximately 900 members on the listserv, and it serves as a place to facilitate discussions that are of interest to lawyers and judges. I also provide weekly summaries of the South Dakota Supreme Court opinions. They're handed down once a week, and I review those cases when they come out, and I provide to the listserv a summary of those decisions, the analysis of what takes place. And beginning the last 2 years or so, I've been providing summaries of the Eighth Circuit opinions when the Eighth Circuit has handed down an opinion from South Dakota. As I said, I remain affiliated with the law school, but my comments here today do not represent the comments of the university or the law schools. It represents my personal opinions. I'm especially pleased to see Representative John Hanson here. He was a student of ours a few years ago. He was one of our brightest students, and he was, I assure you, well liked by the faculty and the staff, And not only well-liked, he was well-respected. He was very collegial. We liked him as a student. And I think he got lots of questions in law school because when he came to law school, he had previously served in the legislature. And I think the number one question that John was asked in law school is, John, why did the legislature do that? He got that question from both the professors and the students. My background as an educator is not limited to my degree, which is a Bachelor of Science in secondary education. I taught 1 year of mathematics at Nowlin Junior High School in the Kansas City, Missouri School District. I taught 3 years of college algebra at the University of Missouri while I was attending law school. And of course, I spent 30 years as a law professor, 5 in Houston, 25 here. I have designed my comments to be under 10 minutes. That's the goal. That's what it's been in my test run, so I hope to remain loyal to that, true to that. When you receive a degree in education, you learn many things. You learn how to have lesson plans, you learn about teaching, and you learn about assessment. Assessment is the ability to grade or to determine the student's acquisition of knowledge. I've always valued what I've learned there. I found that when I moved into law teaching, that very few or virtually no law professors or deans have a background in education. Usually their undergraduate's degrees are in disciplines other than education. I've served under 5 deans, 2 in Houston, 3 in South Dakota. None of them had any background in education. I don't believe there's another professor on the faculty at our law school that has a degree in education, and I'm pretty certain there were no other professors in Houston that had a degree in education. I was always comfortable preparing exams, giving tests, and grading the students. And because of that, the deans at both law schools asked that I present seminars on exam preparation and exam taking, and I did that at both schools. Dean Barry Vickery asked me to make a presentation in February of 2000 to our law school faculty as to how to prepare exams for students. To my knowledge, and that was a seminar that faculty attended, and to my knowledge, that was the only organized presentation to the faculty on how to go about the task of assessment. There may have been others, but I don't remember them. In terms of testing, I've always utilized 3 types of questions: multiple choice, short answer, and essay. And so I've utilized those, not necessarily in each and every exam, but over my career. When I arrived in USD in 1990, we had a bar exam that consisted of multi-state, multiple choice questions and essay questions that were written by the Board of Bar Examiners. The Board of Bar Examiners are attorneys who serve on a committee, and their task, they have a very important task. They determine whether an applicant is qualified to be admitted as a lawyer. One part of that is the examination process. The Board of Bar Examiners looks into many things. An applicant to the bar must fill in a very detailed application, going over every aspect of their history, criminal, jobs, references, and those are explored. And the Board of Bar Examiners conducts hearings on moral character and fitness. This is exactly what the board should be doing, and the board should continue doing that. And nothing I say here today has any criticism for how the board is conducting its role in determining moral character and fitness. But when I got here, the Board of Bar Examiners worked closely with the faculty. And I worked with the examiners as did other faculty members, telling them what we taught. We gave them our curriculum, we gave them our course materials, and we answered questions. And the Board of Bar Examiners themselves, these attorneys appointed by the Supreme Court, wrote the questions. And these questions were on South Dakota law. And our graduates, when they took the bar exam, they took these essay questions prepared by the Board of Bar Examiners, and the multiple choice questions. These questions were spot on. They tested the material over which we taught the students at the law school. I was pleased with those questions. We'd get feedback from the students as to how they worked. Now, if a student did well, students, some do better on objective, some do better on essay. And if a student did better on one part and not the other, they could still be licensed. In other words, they would look at both scores. And so a student who did well on the essay portion could still be licensed as a lawyer, even though that student did poorly on the multiple choice question. The multiple choice questions, as an educator, I've always had grave concerns about the multiple choice questions, which come from the multi-state committee. My primary concern, although it's not my only one, is these are artificially time restricted. The questions, they have 200 questions, 100 in the morning, 100 in the afternoon. And the students are usually given a long hypothetical on one page, followed by one or two questions. Now you have many, I think there's a broad spectrum among everybody. We all have different IQs. We all read at one level. I've always been a slower reader than my companions. And so if you have students who are methodical, slow readers, they simply do not have time to finish the questions. The common strategy for this bar exam is when you get done and time is called, you take the remaining 10 or 15 questions you haven't gotten to and just go color in answer C, because hardly anybody finishes. Now, there is no doubt in my mind that these multiple choice questions punish students who are methodical and slow readers. I had a conversation about a week ago with one of the members of our board of bar examiners, and he said, Roger, your tests, all tests have time limits. Every test you gave in law school had a time limit, and that's true. Every test I did give in law school had a time limit. But I never had a single student fail to complete the exam in time. There was never a problem with time. And so one of my questions is, if we have the bar exam to protect the public, why are we protecting the public from students who are methodical and slow readers? I see no harm there, and I don't see the purpose for these artificial time limits. I have other issues with these exams. They're not testing over South Dakota law. They're testing over national law. These questions are not prepared by anybody in South Dakota. There has been an entire cottage industry developed over taking the exam itself. Not only do you have to go through law school and take 90 hours of substantive law, you now have to learn to take this test, which to me it's like preparing a contestant for the game show Jeopardy. The ones with the high IQ who can read quickly and hit the response quickly are the better ones. And that's exactly what that multi-state bar exam is with respect to the multiple choice questions. I've never been comfortable with that. But nonetheless, it was there. And I will tell you this, that from 1990 to 1998, that's when we quit having our bar examiners prepare questions on South Dakota law. The testing process worked well. I had no criticism. Although I'm not a fan of the multiple choice questions, the attrition rate on the bar exam during that time was typically 5 to 10%. By the way, the attrition rate for people who go to law school is around 10%. So in other words, if you have a class of students that enter law school, only about 90% of those students will graduate. They'll either decide to quit on their own or they'll be dropped out academically. So the law school itself had this attrition rate of 10%, and when they took this exam, there's another attrition rate, and so the 5 or 10% would have the opportunity to go back and retake the exam. In 1998, the Board of Bar Examiners decided that it would no longer write questions. And so the Board of Bar Examiners has gotten out of the business of writing questions for our bar exam. And that task has been transferred to unknown authors on a national basis. They utilize the multi-state essay exam. And so there's other components. There's an Indian law question. There's an MPRE. I won't get into those details. I'll stick to the basics. So basically, we have essay questions prepared by unknown authors across the country and multiple choice questions prepared by unknown authors across the country. Now, as a law professor, I, in fact, wrote some of these essay questions. We were offered $500 a question, and so I took that up. And so I prepared these essay questions for the national conference that would be distributed nationally. If you authored a question, you were not allowed to know where the question was being utilized, and the schools that are using the questions were not told where the questions came from. The questions were artificial because you were not allowed to talk about state law. You were not allowed to talk about South Dakota law, which is what I taught primarily. So I had to make up a question that was rather bizarre. It was set in a fictional jurisdiction testing national principles. I did that because I got paid $500 to do that. But I always felt sorry for the applicants in Rhode Island or Georgia or Idaho or Illinois who were taking my questions. I mean, I had no idea what they were learning in law school, and I couldn't use what I was teaching because it was South Dakota law. But I did that, and that's how it works today. So our bar examiners today, these lawyers who work on the committee, they grade these essay exams. They didn't write the exams, but they grade the exams, and they grade them based on answers that are provided for the authors that are unknown. That's the way our system works. The possibility of doing well on the essay question and not doing well on the multiple choice questions, remember, under that system originally, you could still pass. That was removed in 2015. So the Board of Bar Examiners said that doesn't exist anymore. You have to get a determined grade on both portions of this exam, none of which come from South Dakota law, none of which. Additionally, in 2015, they started upping the cutoff point, making it more and more difficult to pass the exam. The bar passage rate for my students, for our students in 2016 was 39%. In subsequent years, it was 45%, 52%, and 60%. Now, this is the rate applied to first-time takers. That's the statistic. I think it's inappropriate for among other things, I think it's inappropriate for the Board of Bar Examiners to keep moving the goal line. They keep changing the nature of the test, what's going to be tested on, the factions of the test, and the standard that you have to reach in order to pass the test. And then also they've changed the fact that you can do well on one and not so well on the other and not pass the test. So I think that's inappropriate. I have no problem with the diploma privilege. Chief Justice Gilbertson was a diploma privilege admittee. Many members of our South Dakota Supreme Court have been diploma privilege admittees. Many distinguished members of the bar in South Dakota, including Bob Ryder and Peer, who was recently honored, was a diploma privilege admittee. Finally, there's two final things I want to say. I've passed out this handout, and this handout tells you what the mission of the law school is. And if I could read the primary portion of the mission of the law school. USD Knudsen School of Law prepares students for leadership in the administration of justice in South Dakota, including in rural areas where the demand is great. So our law school has a mission to teach our law students how to practice law in South Dakota. But before they're allowed to do that, they have to take a bar exam that has nothing to do with practicing law in South Dakota. It's based on national standards, based on questions submitted by people who have nothing to do with South Dakota. This is our mission. To me as an educator, that's like I finished teaching a course in algebra, and when the students go in for the final exam, they get an exam in geometry. That's how it works in South Dakota today. And as I've already mentioned earlier, the bar exam, the competency there, the supposed competency or knowledge of what you have in your head about what the law is, that's just one small component of licensure. The other components are moral character and fitness, and those are indeed important components. But I think we need to stay in the lane here, and we need to see that competency is already taken care of at the law school, and we don't need to draw this bridge that people who are slow readers and methodical, and who, by the way, would make the best lawyers. I want a lawyer who is methodical, a slow reader, who takes the time to research, prepare, and go into trial.
Thank you, sir. We will entertain further proponent testimony for House Bill 1073.
Thank you, sir.
Good morning.
My name is John Fitzgerald, and I am a state's attorney. I've been a state's attorney here in South Dakota since I was 24 years old. And I'm a proponent of the diploma privilege, House Bill 1073. South Dakota is now, according to the American Bar Association, 46 out of 50 per capita in lawyers. And some people might think that's a good thing, but it's not if you really need a lawyer. Because what this really means when we're 46 out of 50 per capita lawyers is that people in South Dakota, your constituents, don't have access to legal services in our state. The most affected are the people in rural South Dakota. And when you get right down to it, most of South Dakota is rural. People on limited income, people with disabilities, veterans, single parents, most of the middle class is all affected by the fact that we are 46 out of 50. Our bar exam was supposed to assure competent legal services, but instead it's erected a barrier where the price is so high people don't have access to legal services. The opponents of the diploma privilege, they're going to say, well, this protects the consumers. Well, ask yourselves when they say this is protecting the consumers, is it really just eliminating competition? Because competition drives price down. Consumer protection of legal services is meaningless when only a few members of society can access it. And what it does is it reinforces a belief in our state of South Dakota that we got two forms of justice, one for the rich and powerful, and then another system for everybody else. We had the diploma privilege in South Dakota until 1983. Our class sizes were 72, and we were limited to 72 because that's all the old law school would hold as far as the size of that building. Then in the mid-'80s, they convinced the legislature we needed to have a bigger law school. And so we built one so we could have more students. But this is what's happened. When we adopted our one-of-a-kind, non-compensatory bar examination in the state of South Dakota, this is the numbers. 2019, the USD Law School graduated 51. 33 took and passed the July bar exam in South Dakota. 2020, 57 students graduated from USD's law school. 27 passed the July bar exam. 2021, 60 students graduated from USD's law school. 33 passed the July bar exam. The opponents of this bill are disingenuous because they're going to say the diploma privilege, it doesn't protect the public. Then when they say that, then you ask them, where's your letter to the state of Wisconsin, telling the state of Wisconsin that you guys have had diploma privilege since statehood aren't protecting your consumers of legal services in your state? Where's their letter to New Hampshire telling the people in New Hampshire, hey, your diploma privilege plus program doesn't protect the consumers in your state? Where's their letters to the state of Washington, Oregon, Utah, Louisiana, the District of Columbia in 2020 when they had an emergency adoption of the diploma privilege in those cases, in those states? Where's their letter telling them, hey, you guys got a problem, you just let in a bunch of unqualified people? Where's their letter to the state of Oregon today? Oregon is set to adopt the diploma privilege permanently. The opponents will offer no proof that the bar exam protects the public from unfit lawyers. There's no proof other than the opinions of some bar examiners and some lawyers that this bar exam is contributing in any meaningful way. They're one of a kind. Any meaningful way to improve the quality of legal services, or it's protecting your constituents. There's studies. There's a study from Monterey Law School that said there's no correlation on high pass score rates and protection of the consumers. There's a study by Barb Karp, and she said there's no ascertainable proof that the bar exam and the MPRE, that's a ethics portion of it, protect the public. 2020, it's her study. There's Mr. Church, he's a graduate of the University of South Dakota's law school. He did his own study, said that there were less complaints about diploma privilege graduates than there are against ones that have had passed the bar. So you know, and as Professor Barron said, the bar exam that we have in South Dakota does not test over South Dakota law. It tests over the law of nowhere. It's not a valid test of lawyer skills. The aspect of the test that is the biggest barrier is the multiple choice part. And this is where they give you half a page of facts, and then they give you multiple choice questions where two of the answers are probably right. And you got 2 minutes to pick the best one. That is unrealistic. What lawyers do is they analyze complex facts. Sometimes it takes hours. Sometimes it actually takes days to analyze these complex facts, not 60 seconds. Lawyers don't get asked questions by judges or juries about multiple choice questions. Lawyer skills, to me, is about gathering facts, negotiating with your adversaries, organizing volumes of information, simplifying complex and being able to research. The MBE, that's the multiple choice portion, has 200 timed questions, got 2 minutes apiece on them. 25 of these questions they don't even use to score for your test score, because they use them for equating purposes only. So you may have actually passed the bar, but the questions that you got right, they didn't add those into your score. They were just there to make sure that from time to time when the bar exam is given, that there's some equity with the multiple choice portion of it. And so then ask the proponents from the Board of Bar Examiners to explain this. If time in answering questions is so important, then why, when the Board of Bar Examiners got this rule change to get our one-of-a-kind bar exam, they missed their own deadline by 6 months? It's true. If lawyers are supposed to know the law in South Dakota and we're supposed to follow the rules, ask the Board of Bar Examiners why it is that we don't follow the rules regarding scaling the essay, the written portion of the bar exam, to the MBE. The MBE is an objective test. The essay questioners are not. This is what Dr. Albanese has said. He's the designer of the test. He's a psychometrician. That's a person who's a statistician dealing with tests. He's with the He's with the National Conference of Bar Examiners. He has told the states that he recommends this be done because it helps make them more objective. We don't do that. We don't follow that rule. That's why I got this one-of-a-kind bar exam that everyone has problems with. That's why we need to go back to the diploma privilege. Let's have some equity. Let's protect the legal consumers of these services here in our state. You know, let's not be 46 out of 50. The Constitution, Article 5, Section 12, gives the state legislature the authority to restore the diploma privilege. The NCB that designs this test is a monopoly, and they control who gets licenses in our state. And they're in a different state. It's an out-of-state entity. The bar exam does not measure lawyers' dedication, their tenacity, their willingness to provide services to the disadvantaged, or the contributions they're going to make to our state. It simply is this. It assesses who is the best at answering multiple-choice questions. Our bar exam does not test South Dakota law, so how does it protect our state? The people who profit from this bar exam, they don't fund our court system. They don't fund our law school. It's the legislature who protects the people who live here in South Dakota. And it's the people of South Dakota who fund these law schools. And they fund our court systems. The diploma privilege is, in fact, the quickest and the least burdensome pathway to achieve the goal of access to quality legal services without costing the taxpayers. We don't need another study. We need action. The dean of the law school makes approximately $282,000 a year, and he's going to get a raise. With that kind of money and with his brilliance, he can handle this situation and make it right by giving us the diploma privilege and implementing it in a successful way. When we over-rely on a claim that the bar exam is protecting the consumers, we've inadvertently, but we've significantly contributed to denying access to legal services to the people who live here. Being a lawyer is not just about making money and keeping the profession limited. It's about public service. It's about helping people. It's about protecting people. The diploma privilege incentivizes South Dakotans to stay in our state. And if the diploma privilege is going to be brought back, it's going to be brought back by the legislature, because the State Bar of South Dakota and the Board of Bar Examiners, well, they got other interests. I'm asking you to grant the diploma privilege for South Dakotans who graduate from USD's law school, like we used to do, because the South Dakota young people who provide access to the legal services will be providing it for future generations of the people who live in our state. And I guess I just end with this little quote that I remember. It's the race is not won by the swift, nor the battle by the strong, because time and chance happens to us all. And so what that means is that by the grace of God or by fate, you don't have to be the smartest person to succeed in any profession. And thank you.
Thank you, Mr. Fitzgerald. We are 29 minutes in at this point, and so I'm going to grant 10 more minutes, but then that's going to be it. So I would ask that those that want to continue to testify to be succinct. We're in a committee hearing, not in a courtroom, so let's keep it right to us. And No, and we've got other business to get to, so I'd just ask that you to keep moving this along. Thank you.
Be quick. My name is Anthony Murdoch. I am here on my own behalf. I did send out an email to the members of the committee before this, but I just wanted to come up and speak again. I had some other points. Many of my points were actually made by previous speakers, but I wanted to reiterate that, number one, having gone through many of these steps and experiences, I did graduate from USD in 2021, and I have had numerous problems with. Pardon me. I've had numerous experiences with not only preparing for the bar, but the organization that makes and administers the bar. The MPRE, which is the ethics portion, it's not administered with the bar or at the same time, is made by the same organization. But first of all, I am disabled. I am a disabled veteran. I have many issues which, like previously stated, causes me to be a little bit more methodical in reading my questions and thinking about my answers. It doesn't mean I am slower in my thinking. It doesn't mean I am not capable of coming up to my answers the same way that somebody else is. It just takes me a little more time. Going through the process of trying to get an accommodation from this organization was quite frankly disgusting. So I had to send in more than enough information to get an accommodation just to get a little bit more time for this. They wanted my medical records. They wanted basically everything so they could make a determination. And this is the National Conference of Board Examiners, or of Bar Examiners, excuse me. They basically wanted enough information so they could re-diagnose me and basically determine whether or not I was disabled. That's pretty gross, in my opinion. They're not medical providers. They're not my medical providers. And for them to say that they need mountains of my medical records, basically from the VA, just to make a determination whether or not I could have a few more minutes was more painful than it needed to be. I ended up getting an accommodation for the MPRE, not what I would have liked, but I ended up needing that time just to finish. I ended up passing the MPRE. But what was not said before as far as the bar itself is the MBE, the multiple choice question, is 175 scored questions. That's over 7 required topics. So 7 topics that are required classes at USD. What's not said is there's 25 questions out of these 7 topics. You can fail all 25 questions on the bar for this one, for one specific topic, and still pass. What you can't do is fail one required class at USD and still graduate. So you're still getting that experience from USD, but if you fail the bar for those 25 questions, you can still pass, if that makes sense. So I really have a hard time understanding how this is a measure of competency for lawyers. Additionally, it has been said before that after law school, you spend months, definitely weeks, and most likely thousands of dollars, hundreds or thousands of dollars on prep courses just to take this test. USD actually has a class that's now required just for bar prep. So you take this class, you cram and cram and cram to take this test, and then you data dump. A few months after, probably most people don't remember a lot of the stuff that they studied for. I would be really curious to find lawyers, attorneys that have taken the bar that can take it and pass it again a year, 2 years, 5 years later without the same kind of preparation. So if this test is made to be a measure of competency, then why is it not being given periodically if it's a measure of competency to make sure that they're still competent? If you have an attorney that's practicing tax law for 20 years, why aren't they be given the bar? Or why aren't they given the bar periodically? Because the bar tests over a lot of different legal areas: criminal law, civil law, torts. So to expect somebody to come right out of law school that's been studying all of this for 3 years, then cram to take a test that they're going to data dump afterwards is not only redundant, it's just wasteful. And then the test itself is beyond a burden for some students. Not because they can't take the test, but because the test makes it so hard for them to take it. And this is all in addition to what's been said before. So, one question that I've heard before in an argument was that there would be more classes that need to be required in order to make this diploma privilege viable. I don't think so. Like I've said, there are 7 topics on the multiple choice. All of those are required classes at USD. For the essay portion, there are 6 essays. One of those is removed by the Board of Bar Examiners and replaced with an Indian law question. Indian law is not required at USD. Of the other questions, there's 6 essays. So out of those 6, since 2013, at least 50% of those questions have been from required classes. Now, for those not required classes, there's 4 other topics of that. It would be extremely unusual for a student to graduate from USD and not take at least one of these elective classes. Trust and Wills is the biggest one. Trust and Wills is the largest elective class at USD. Now, on the bar exam for the essays, there's actually 2 different subjects, trusts and wills. It's 2 different subjects. So if you take this one class, it hits 2 different subjects. Now, on the bar, every time they take it, it's different subjects for the essays. So you're not even testing the same thing from test to test. So if that's also not a same measure of competency if you're testing the same things, or if you're not testing the same things for the same people. That's another big complaint I have. And lastly, one of the students in my class, a very outgoing student, was very, very good in studies, was very outgoing with extracurricular activities, graduated, took the bar in a neighboring state, a UBE state, a universal bar state, of which South Dakota is surrounded by. This person took the bar in this state and failed it. Well, since it was a universal bar state, they were able to transfer it to another surrounding state, which was also a UBE state. That score passed. So they only took the bar once, failed it, transferred it to another state, was admitted in that second state, and since this person works only in federal issues, all they needed was to be licensed in one state. So this person is licensed and works in their normal state, in the state of which they failed the bar. And that's perfectly acceptable for their job, for all of their purposes. And that's only because the universal bar, every state can pick their own threshold of what's considered passing and not, even though it's the exact same test. So if that's a measure of competency, then competency is different wherever you go. That all would have been avoided as well if it would have just been diploma privilege. There wouldn't have been all of that waste for all of that cramming and all of that waste of time and money and lost revenue when the person could have just started working immediately because they knew that all they needed was a license for federal issues. So that's another person that would have had an issue. And again, this is an issue where this person too would also, after a few years, be able to transfer their license to South Dakota, because South Dakota doesn't require a person to take the bar under quite a few circumstances where they can just transfer it from another state when they've been working in a state other than South Dakota for a number of years. So again, if that experience as a tax lawyer or as something else for so long, they can come into South Dakota and not take the bar and still be licensed. So a tax lawyer can come here and say, I was a tax lawyer in Minnesota, but now I'm going to be a criminal attorney. Then there's no licensure other than, here's your license and here you go. The bar exam, they've taken it once, so all right, you're good to go. So the bar exam simply isn't a measure of competency, period.
Thank you, Mr. Murdoch. Further proponent testimony, House Bill 1073. And if your comments can be kept brief, that would be much appreciated.
Committee members, thank you for this opportunity. It's a little odd to sit down because I was taught in law school you stand when you present. My teacher also told me keep your remarks onto one page if you can. So I'm going to do so. Aaron Eastland, District 34 out in Rapid City. Been practicing law for over 20 years. My father practiced law with me currently, and he's been practicing for 51 years. Last year I got to watch him get his 50-year pin for practicing law. And when he received that pin, it struck me now here yesterday that starting in 2023 and going forward to 2033, those people that step up and get their 50-year law pin will have all received their law degree and their right to practice in South Dakota because of the diploma privilege. What changed in 1983 to bring in the bar exam? I'm not really certain. What I do know is it's continually eroded away from South Dakota law values. It's turned its way towards more national values, and this progression has continued and has gotten worse. For 39 years, this has gotten worse. It's time for this committee, this legislature, to pass 1073 and reset the balance, and also correct a very fundamental problem. We've now spent 39 years leaving talented people on the bench. They are sitting out the game because they couldn't pass a time test that has no reflection of how law is practiced in South Dakota. I've practiced in every corner of this state and right here sitting in this building. I've put on 20 and 30,000 miles covering different counties because there aren't enough lawyers around. And we're leaving talented lawyers on the bench where they can't get out there and help people. This is the right bill, and it's the right bill at the right time, and I would hope you would pass this forward onto the full legislature. Thank you very much.
Thank you very much. Further proponent testimony, House Bill 1073.
Good morning, Mr. Chairman,
Morning.
members of the committee. Roger Tellinghusen. I'm a Rapid City lawyer, and I appear today on my own behalf. I sit before you as an example of the diploma privilege. I graduated from the University of South Dakota Law School in 1978. 1975, when I was a senior in college, my senior year, my spring semester of my senior year, I had taken the LSAT, the admissions test, to get into law school. And I was notified by Creighton University that I had been accepted into their law school. And so that's where I was going to go to law school until I then also was accepted into the University of South Dakota. Financially, it made a difference. But more importantly, the diploma privilege made a big difference to me in my decision. Now, some would say that over the course of my 44-year career, 44 years, May 13th of 2022, excuse me. I haven't done anything spectacular, but I've had great opportunities in South Dakota, and I didn't have to take the bar exam. I've been a member of the United States Supreme Court Bar since 1985. I argued in front of the United States Supreme Court. My successor as Attorney General, Mark Barnett, was also a beneficiary of the diploma privilege. Supreme Court Justice Judith Meyer-Henry was a beneficiary of the diploma privilege. The thing that has always kind of upset me about the fact that kids going through law school who have passed all their classes in law school here in Vermilion, taken the test and they can't get admitted to the bar is the tremendous financial burden that's created for them. Some kids come out of law school with an $80,000 student debt. Now, they've passed all their classes in law school, but they can't get admitted to the bar because of the nature of the test. I don't think that's fair. And I think we're missing the opportunity to have a lot of young lawyers in this state who are eminently qualified, but who, for whatever reason, haven't taken a test very well. For those reasons, I rise in support of House Bill 1073.
Thank you, Mr. Tellinghusen. For the proponent, House Bill 1073. Anybody left in the room? We got one more here. Good morning.
Good morning, Chair and members of the committee. Lisa Nolan, registered lobbyist and Deputy State Director with Americans for Prosperity. We often, there was a lot of good things said here, so I'm just going to jump in at the end here and say we often look at licensing regulation issues as a barrier that keeps good people out of professions. There's often we see some protectionism within the field, And the result of that, unfortunately, is that you don't have access to the same full market that you would. And so you don't have the affordable options that you should have. So many people aren't even able to choose their own lawyer from a market of competent folks. So we would just encourage you to look at this as removing a barrier and allowing for more choice. We know that is what drives a good product. Thank you so much.
Thank you for the proponent testimony, House Bill 1073. I know we've got 3 gentlemen online that would like to participate. I'm going to allow that, but I'd ask you to keep your comments brief and go to Mr. Holt first.
Thank you. It's an honor to address this committee about an important issue. I wholeheartedly support HB 1073. The current system, in my opinion, is flawed, and the reinstatement of diploma privilege is necessary and the acceptable resolution. It is the right thing to do. My comments here today are my own views and do not represent the views of the Minnehaha County Public Defender's Office. The state needs to allow law firms and legal agencies to recruit their employees without being hampered by restricting the hiring of those who have only passed the exam. The bar exam does not ensure the admission of good and competent lawyers, but conversely keeps some of the best potential legal hires from ever being employed. I graduated from the University of South Dakota School of Law, but I have never taken the bar exam here. My wife was working in North Dakota at the time, and therefore I took the North Dakota bar and I passed. I am licensed to practice law in North Dakota, and I have been since August of 2020. I have recently been hired by the Minnehaha County, and I moved here just last week. Although I am qualified, I have no discipline, and I am in good standing with the Bar Association in North Dakota, I have to go through that grueling process again in July just to be licensed here. Currently, I practice here in South Dakota with the supervision of another lawyer. So the vacancy I filled actually will not be fully realized until I pass the bar. Furthermore, another lawyer has to be pulled from whatever they are doing at the time to supervise me. By reinstating diploma privileges, the state will have a recruitment pool full of incredibly talented, those of good character and potential North Dakotan Supreme Court justices. The bar exam is intentionally tricky and complicated. For instance, in the multiple choice section, worded in complex legalese, a question will state, choose the most correct answer. All the answers could be correct, but in haste, we have to translate that legalese into comprehension. Now, the 4 correct answers, we have to choose the most correct. For example, answer A will be worded exactly the same as answer D, with the exception of one word. The word change, the word may, will be changed to the word shall. The examinee will have to choose in seconds so that he or she may finish on time. When there is ice and snow on the roads, I am making sure I have good tires. I leave early. I drive much slower than the speed limit just to get to work safely. Here, the examinee, instead of being able to slow down to fully comprehend a question, is compelled to speed up to finish on time. I ask you to reinstate the diploma privilege. It is needed. It is the right thing to do. Thank you very much for your time and consideration.
Thank you, Mr. Holt. We'll go to Church.
Thank you, Mr. Committee Chair. I'll be brief. My name is Jeffrey Church. I'm a resident of Vermilion, South Dakota. I'm a retired Army officer who attended the University of South Dakota's School of Law. I graduated and was awarded a Juris Doctorate in May of 2021. I have not taken a bar exam, and I do not plan on taking a bar exam. I'm currently a PhD student in the Sustainability Program at USD. If South Dakota had a diploma privilege when I graduated from law school, I likely would have sought a job as a rural attorney in South Dakota, as my primary income needs are met through my military retirement pay. And now I'm just going to jump through 3 pages of testimony to my conclusion. You should have 3 documents from me that were supplemental testimony that cover everything you've heard and more in great detail. So if my conclusion sounds a little bit disjointed, it's because we've skipped 3 pages of testimony. You may want to ask why I just didn't take the bar exam. The answer is simple. The bar exam has no evidence to support the claim that it protects the people of South Dakota from those unfit to practice law. In fact, research shows the opposite, and that was mentioned in other testimony. I'm the Mr. Church that did the South Dakota attorney discipline research. The bar exam violates the fundamental right to practice law as held by the United States Supreme Court in an 8-1 decision in New Hampshire v. Piper. The bar exam is a per se violation of the Sherman Antitrust Act in nearly every respect. In part, quote, prohibitions against anti-competitive self-regulation by active market participants are an axiom of federal antitrust policy, close quote. And, quote, when a product is controlled by one interest without substitutes available in the market, there is monopoly power, close quote. The State Bar and Supreme Court are active market participants conducting self-regulation of entry into the practice of law through the single market option of the bar exam. You'll find an entire paper I wrote on the bar exam's per se violation of the Sherman Antitrust Act in the supplemental testimony materials I submitted. South Dakota spent 3 years teaching and testing me about the law. South Dakota required me to successfully complete a professional responsibility course in order to obtain my Juris Doctorate. How could I then participate in a 2-day bar exam that tests no South Dakota law and violates so many of the principles of law I was taught? I could not, I did not, I will not. Thank you for allowing me to testify in support of House Bill 1073.
Thank you, Mr. Church. We'll conclude with Mr. Rains. Is that correct?
That's great. That's correct, Mr. Chairman.
Go ahead.
Good morning, Mr. Chairman and committee members. Thank you for the invitation to speak this morning. My name is Brendan Rains, and I'm a second-year law student at the University of South Dakota Knudson School of Law. This state has an invaluable opportunity for crucial policy reform, one that would not only benefit South Dakotans today, but for generations to come. It's an opportunity to invest in the economy, an opportunity to resolve representative disparities within the state, such as in the rule of practice. And it's an opportunity to strongly incentivize USD law grads to call South Dakota their home. Additionally, it's an opportunity to transform the dynamic of legal education for the better, where we can focus more on rigorously training law students to lawyer and truly assure South Dakotans that their counselors are competent enough to defend and represent their interests to the best of their ability. Moreover, it's an opportunity to encourage inclusivity, where we create a system that, put simply, is fair to all and not to some. As Representative Fitzgerald mentioned, this state had diploma privilege for nearly 7 decades. It's nothing new. But at no point was there a question of the competency level of junior attorneys who entered practice under the rules compared to now. There was also no question of the ethical conduct that was directly impacted from the rule in the same manner. Instead, it worked as it should, producing attorneys that our residents within South Dakota can trust to resolve their problems in the court of law. Even today, as Professor Barron mentioned, South Dakota has attorneys and judges who never took the bar exam, but maintain the standard level of competency that advocates against diploma privilege would expect out of any lawyer who took the bar exam. In this regard, the bar exam is by and large an unnecessary tool that sadly places unreasonable presumptions in the heads of South Dakotans. The exam tests not on one's ability to draft a contingency agreement, negotiate a settlement, or advocate for an indigent client in a capital punishment case, but merely on the philosophical boundaries of the law and how they abstractly apply to arduous fact patterns that likely will never be seen in practice, if at all. Consequently, the exam is centered on a mere regurgitation of knowledge on paper versus an application of an actual lawyering skill, leading to the categorical conclusion that the assertion that the bar exam necessitates one's ability to be competent enough to practice as an attorney is based on a falsehood. It's a deeply deceptive assertion intended to prevent students from saturating the bar, not to satisfy society's desire of ensuring that their counselors are there to effectively defend and resolve their issues. The evidence points in the unfortunate direction, committee members, that the bar exam largely does 3 things and 3 things alone. It gatekeeps to prevent a competitive legal market that South Dakota desperately needs. It marginalizes the lower socioeconomic class through an unrealistic financial barrier. And it contravenes the wisdom of traditional methods of training individuals for a professional practice by sidelining their developed experience for plain memorization of abstract concepts. By reinstating diploma privilege here in South Dakota, the only law school in the state can transition its educational philosophy to one centered more strongly on rigor, practicality, and discipline, 3 foundational principles required of any attorney. It can promise a system that is intended to train future representatives of South Dakotans that is not dependent upon their ability to remember, but their ability to fight for what's right for their clients. More importantly, it can promise a system that guarantees fairness in entering a profession that is the backbone to a free and constitutionally protected people. I implore this committee to take a step back, even for a short moment, and consider the ramifications of what doing nothing for this bill and maintaining the status quo would mean versus how making the bill a reality could make the state be at the center of impactful change for not only itself, but for the nation going forward. Thank you.
Thank you, Mr. Raines. We'll conclude pro-opponent testimony, move on to opponent testimony for House Bill 1073. Any opponent testimony? Good morning, Mr. Chief Justice.
Good morning, Mr. Chairman, members of the committee. My name is Steve Jensen. I'm the Chief Justice of the South Dakota Supreme Court, and I'm here on behalf of the Supreme Court to express the court's opposition to HB 1073. I have some prepared comments, but I appreciate that there are some time constraints as well. So let me start by talking about the primary concern of the court, and that is that this is fundamentally an issue that the Supreme Court should take up and not the legislature. Constitutionally, the Constitution specifically states that the court has the authority and the obligation to regulate the practice of law as well as the admission of attorneys to practice. You know, as I sat and listened to proponents' testimony here today, there's a lot of nuances about this bar examination, and I could talk for hours. And I saw, I think, some eyes glaze when we started talking about the details of the bar exam that I took about 30 years ago, and that every member of the court has taken and passed. And it's a test that is hard. But it's a test that tests the rules of law and the principles of law and requires study to pass. And I think that those responsibilities as an attorney are important. And so constitutionally and practically speaking as well, this is a debate and this is an issue that should be taken up by the Supreme Court, not by the legislature. I think it's important to note we have had two rules hearings on the bar exam in the last 4 years relating to test scores and passage. The court has addressed some of the issues that have been raised and has been responsive to those concerns. What I would tell you, however, is that there has never been a request brought before the court to say, let's get rid of the bar exam. Let's go back to a diploma privilege. There's been no discussion about how that's going to be implemented at the law school, and I think that that's where that discussion needs to be taken place. And to have that discussion in front of the legislature and spend a few minutes to talk about it, I don't think is an appropriate forum to do so. And so I would respectfully request, constitutionally and practically speaking, that the legislature would properly reject this bill and allow the court to take up these issues, which it should do. On the merits, let me just talk about the merits of 1073 briefly. There's been a lot of discussion about the inability of applicants to pass the bar examination in South Dakota. And I think Dean Fulton and Jack Heeb, who are here from the Board of Bar Examiners, will talk a little bit about that. But one of the things that I want to point out that I think is important is that there are 17 individuals, 17 that have not been able to pass the bar exam since 2013. There are about 3,000 licensed attorneys in South Dakota. So over 9 years, that's about two applicants a year that have been unable to pass the bar exam. Now, have there been individuals that have had to retake it? Absolutely. There have been individuals that have taken it several times. After the third attempt, an applicant has to come before the court and request permission to take the bar exam. And we've been very liberal allowing individuals to attempt to continue to study and to prepare for the bar exam and pass the bar exam. And so we're not talking about a large number of individuals that have been impacted by the bar exam. We're talking about a very few. And I think that that's an important issue to understand. This is not an issue that's impacting the practice of law in South Dakota. Has it impacted a few individuals? Yes. And I'm sympathetic to those individuals that have not been able to pass the bar exam and have attended law school. But before we have a wholesale change in our standards for admission, our standards for competency in this state, there needs to be some consideration of how are we going to implement, whether it's at the law school or another basis to address competency. We have an obligation as a court to protect the public. Every time we sign a diploma or a certificate to practice law, we're stating this person is competent to practice law. If the bar exam's taken away, we're then dependent upon the law school to do that. I think the law school does a good job of educating students, but the process of educating a professional is different than the process of determining professional competence. Every profession in South Dakota has a competency examination. I can't think of a profession that doesn't. We're not unique. We're not unique amongst the states. There are 48 states that have the same bar exam that South Dakota has. And so this is not a unique situation at all. And so I want to make sure that there's disabuse any notion that we're unique in South Dakota in terms of our situation with competency to practice. With that said, I would simply ask this committee to reject this bill, allow the bar and the court to address the appropriate standards for competence, and not take this up and move into really a new realm that the legislature has not previously addressed for over a century. Thank you.
Thank you. Further opponent testimony, House Bill 1073. Good morning, sir.
Good morning. My name is Jack Heeb. I'm from Aberdeen, South Dakota. I'm a member of the South Dakota Board of Bar Examiners. I was asked to come today by the Chief Justice. I think somebody from the board had to show up to draw fire, so I think I was the one that was picked to do that. I want to make sure that the committee understands that the Board of Bar Examiners is not some omnipotent group. We serve at the pleasure of the Supreme Court. We're appointed by the Supreme Court, and we have no profit motive, contrary to some of the comments that are made here this morning. In fact, it's the opposite of a profit motive. If you want to accuse me of being a greedy individual, I'm very bad at it, because the amount of time it takes me to grade these exams every year, I could be making money. If that's what it's all about, this is a really poor decision on my part. We don't make rules. The Supreme Court makes rules, and the Chief Justice just commented on that, and they take that seriously. We have had changes made to this exam and to how it's graded and to what the cut score is going to be repeatedly, at least 2 occasions in the last 4 or 5 years. So it's not that the court hasn't taken this seriously, and it's not that the board hasn't taken it seriously. The one thing that I want to make sure that the committee understands is that there's been talk about how this test doesn't test South Dakota law, and that this is some national unknown board. There is an essay portion of this test. There is a multiple choice portion of this test. The essay portion of this test is graded by the 5 of us from South Dakota who are on the South Dakota Board of Bar Examiners. We do not write the questions. We could. We don't. We grade the answers. And to me, it's far more important that we're the ones grading the answers than it is that we're the ones writing the question. There isn't, contrary to what some of the comments that have been made, sure, there are areas of the law that might be different in South Dakota, but we aren't testing South Dakota law. I think it's a misnomer to say the only thing that matters is South Dakota law. When I went to the University of South Dakota, one of the professors that I had was Professor Barron, who's sitting behind me. And I'll candidly tell you, he was one of the best professors that I had. I learned a lot from him. I learned a lot from him about insurance. I learned a lot from him about civil procedure. Things I learned from him in that school, I remember to this day. Very few of them were South Dakota specific, because those principles apply regardless of where you are. And I think Dean Fulton, who will be testifying after me, would tell you that a graduate from the USD School of Law can go anywhere, and that's part of getting a law school education. It's not simply limited to South Dakota. There is nothing unfair, in my opinion, about how we grade the exam. It's not unique, other than we split the essay from the multiple choice, and if you pass the essay, you don't have to take it again. You can simply take the multiple choice again until you do pass it, if you do. No jurisdiction averages the scores together. We've never done that. Nobody does that. They scale them. I'm not going to cause your eyes to roll back into your head and try to tell you what scaling is unless you have questions about that. I'll be happy to answer them. I think I understand it well enough to do that. The hearing has gone past what it should have, as I understand it, so I'm going to stop here, and unless there are questions, I'll yield the floor.
Further opponent testimony, House Bill 1073. Mr. Fulton, would you like to go next?
Sure, Mr. Chairman. Thank you for the opportunity. Neil Fulton, the Dean of the University of South Dakota School of Law. Pleasure to be here. I'd say at the outset that I'm supportive of alternative pathways to licensure, but licensure needs to balance protection of the public and access to the profession, and I don't agree that HB 1073 does that. I would be happy to answer questions at the end, Mr. Chairman, about placement, recruiting, other things from the law school, but I really just want to highlight a couple of things. First, there's been some discussion about alternative pathway programs in other jurisdictions. None of those programs look like this bill. Each of them prescribes by court rule what the law school that has diploma privilege must offer. And in New Hampshire and in Oregon, there is in fact still an examination component to that admission process. It is just a different exam process than the one under the bar exam. So the thing I would tell you that as we build curriculum down here, we can do that one of two ways. We can do that in partnership with the bar and the court and the bar examiners to make sure that the curriculum we are building is aligned with the needs of identifying professional competence that is somewhat different than what we do down here, like Oregon, Wisconsin, New Hampshire do, or you can simply trust that the law school in perpetuity is going to get this right. We try to get it right, but I would say that our interests at the law school are different than the bar examiners, and that seems like it swings that balance a little bit too far towards the law school and us having control of this question of protection of the public. Why is that the case? A little bit about the nature of modern legal education. The University of South Dakota, more than a lot of law schools, prepares graduates for practice. Most of our graduates are going to go out and practice in some form, and we really try and align our curriculum with practice. But every year, we have a significant number of graduates who come in with no intention to practice. We have students coming in who never intend to take the bar exam because they're going into business. We have folks who get joint degrees because they want to go into academia or because they want to go get something else. We have folks like Mr. Heeb's son who came here to get a JD because he wants to be a athletic director at a university setting, and it takes 3 years to get a JD and 6 years to get a PhD. Not all of our graduates then, as a result, are taking a curriculum that is aligned with practice. And that's just the nature of what we do. We have to meet the needs of all of our students. Another reality of current law school education that I would say is if you don't like a multiple choice exam deciding the future of someone going into practice, then you're really going to hate diploma privilege. Because we are required for accreditation to administer the LSAT or the GRE to all students. That has no connection with competency to practice. You are, in fact, moving to diploma privilege, putting more weight on a multiple choice exam that has less to do with the practice of law. If we don't like the structure of the current bar exam, I agree. It could be better. In fact, the National Conference of Bar Examiners agrees and is undergoing a big renovation of the bar exam called Next Gen that will focus more on practice skills. It is abandoning the 200-question multiple choice in favor of practice exercises like the MPT that's currently administered. And for us at the law school, I think it better aligns with what we do and the goals we have in preparing students for practice. Mr. Chairman, I'd be glad to field questions again about our entering credentials, how we teach, where we place, the opportunities we would see. But most importantly, I would just say that any licensure of a profession runs risks of letting too many people in or keeping too many people out. We will never strike a perfect balance, but trying to strike the best balance we can requires coordination between the profession, the educators, and the courts in this instance. This bill, in my opinion, does not appropriately strike that balance, and I think that we should have a different conversation in a different forum about striking a better balance rather than passing this bill.
Thank you, Mr. Fulton. Further opponent testimony, House Bill 1073. Good morning.
Good morning, Mr. Chair and members of the committee. My name is Andrew Fergal, and I'm the Executive Director of the State Bar of South Dakota and a registered lobbyist for the same. I think it's important for every profession to have some requirement beyond simply graduating from law school that tests for a minimum level of knowledge and competence across several areas of the law. Whether it's medicine, law, or another profession, licensure exams exist for a good reason, to protect the public. Since this bill was introduced, I've been talking to many members of our organization about their thoughts about this proposal. And what I've been hearing from many of them is that the bar exam is important, that knowing passing the bar was required for admission to practice law made them a better law student, and they were better for taking the bar exam, and their clients are better for it too. To pass the bar exam, an individual has to make a commitment to preparation, develop and maintain a study schedule, eliminate distractions, practice answering questions, and manage stress while preparing for the exam and taking the exam. Similar commitment and skills are needed to practice law successfully. The fact is, a lawyer's life is one of constant tests by clients, judges, and colleagues. And the bar exam is but the first serious hurdle one must overcome to be a good practitioner and serve the public with competence. I think this is the most important point I want to make, and I don't want to repeat what other people have said. But if there is an alternative pathway to bar admission, and those alternative pathways are to be explored, that discussion should be with the Supreme Court after considerable study and input from stakeholders. The State Bar does not believe that House Bill 1073 is the right vehicle or the right venue for this important topic to proceed forward, so we'd ask you to vote against this bill. And I'd stand by for any questions.
Thank you, Mr. Fergal. Further opponent testimony, House Bill 1073. Good morning.
Morning, Mr. Chairman, members of the committee. My name is Justin Bell. I'm a registered lobbyist for the South Dakota Association of Criminal Defense Lawyers. I'm not going to repeat a lot of what was said. I would say that my comments would echo Dean Fulton's and Mr. Jack Heeb's comments regarding a lot of what they testified. My clients are sympathetic to the argument that there could be ways to improve the bar exam. I don't think anybody disagrees that that's something that should always be looked at. We would submit that the Supreme Court is the more appropriate body to take a look at that and make sure that that happens over the next years. But from a different perspective, the one thing that my clients wanted to add is a lot of our clients are in a situation where they're not the ones choosing their own clients. They're appointed a lawyer from the court. And so a lot of times you hear the arguments that, well, we should let people, choose their lawyer, hire the lawyer that they want. That solves the situation. But a lot of our clients aren't in that position. They're appointed an attorney that a judge picks for them, and that's an appropriate process. Certainly you don't get to pick your own lawyer in all circumstances. But there needs to be some sort of mechanism in those types of situations where the state regulates those attorneys to make sure there's a base level of competence. And we believe that this bill goes a little bit too far Certainly some valid comments about the test structure, et cetera, but completely throwing out the baby with the bathwater with this piece of legislation is not the best way to move forward, in our opinion. So we would ask that you reject this bill and defer to the 41st day. Thank you.
Thank you, Mr. Bell. Further opponent testimony, House Bill 1073. Good morning.
Good morning, Mr. Chair, members of the committee. I'm Steve Siegel, and I'm the registered lobbyist for the South Dakota Trial Lawyers Association. We, too, rise in opposition to House Bill 1073. I'd like to say, first of all, I get it. I mean, you get into law school, you go through 3 years of law school, and you knock down everything that's put in front of you. You pay a lot of cash for tuition, and then you get to this 12-hour exam after law school, and they say, hey, you didn't pass that, you can't practice law. It's harsh. I mean, I understand that, and the thought of that, I mean, I got lucky and passed the first time I took it, but I know there are a lot of bright people that took the bar exam that weren't able to pass it, so I understand. I'd also like to say it's somewhat of an uncomfortable position for me today because I have a lot of respect for Professor Barron, Roger Tellinghusen, Aaron Easlin was a classmate of mine, so it is somewhat uncomfortable position for me. And I would like to say when Professor Barron first came up and started to talk, my heart skipped a beat because it took me back to 1995 and classroom 101 there. We had 94 people in there, and Professor Barron used to make a stand when we would recite. So when he called on you, you had to stand up in front of all your classmates, and believe me, if there's a motivation for preparing for class, that was it. So. But like I said, he was a heck of a law professor, and I do have a lot of respect for him. I do disagree with him on this issue, but he was definitely one of the best law professors that the University of South Dakota has seen down there. I just think this bill would take some time. I mean, if we're ever going to implement this, it's going to take some time. There'd have to be some significant modifications down at the law school, I think, as far as preparing students to practice in the state of South Dakota. And in this situation, members of the committee, I think we should defer to the South Dakota Supreme Court and the Board of Bar Examiners. And for those reasons, I would ask you to please vote red. Thank you very much.
Thank you, Mr. Siegel. Further opponents, House Bill 1073. Further opponents for House Bill 1073. Seeing none, we'd open it up to rebuttal of the prime sponsor. You bet. Maybe would you turn your microphone on and then identify yourself?
Yeah, sure.
Thank you.
My name is John Fitzgerald, and I've been a South Dakota State's attorney since I was 24 years old. I am a proponent of this bill and talking in rebuttal succinctly. Article 5, Section 12 of the South Dakota Constitution leaves this authority to change the rules regarding bar admission to the South Dakota legislature. It's what it says in its last sentence. Now, the Chief Justice is on the Supreme Court, which ultimately determines what laws and what our Constitution means. And so if we were in a litigation situation, that court would have the right to weigh in. But that's not where we're at right now. If this law is passed, and I urge you to pass it, then maybe there'd be a challenge in the circuit court, and maybe that challenge would get to the South Dakota Supreme Court, and then the Supreme Court as a group, after hearing argument and being briefed on the issue, would make a determination as to who's got the authority. But that's what the Constitution says in its last sentence. 2, there are a lot of individuals who take the bar exam once in South Dakota, fail it, they go to another state, maybe they pass it, but under South Dakota rules, it's 3 strikes and you're out. If you take the South Dakota bar exam 3 times, that's the end of it. We don't even apply that to people who commit felonies and get convicted 3 times. You're 3 times and you're not out when it comes to crime, so I don't know why we impose such a harsh rule on the people who take the bar exam in our state. But that's what we do. And so this business of there's only 2 per year that have gone through our law school and have not passed, well, that would actually speak to the argument of let's just have a diploma privilege then, because if there's only 2 people that are not passing the bar exam, why are we spending all of this time, energy, and money on a bar exam if only 2 people can't pass it? I say statistically it is higher than 2 people per year at our law school. But, of course, the dean would be the one with those kinds of figures, and I would challenge anyone from the law school to come forth with those figures to substantiate that only 2 people a year are not passing the bar exam. We're paying the University of South Dakota's law school in Vermillion $5 million a year That's what it costs the taxpayers. And with $5 million a year, it wouldn't be very hard for them to engineer a program immediately where persons who have gone through the rigors of law school for 3 years and have passed the bar exams and passed the character and fitness examination given to us by the state could not be then licensed to practice law in South Dakota. Again, it's a pathway to achieving lawyers access to legal services for our citizens in a quick and beneficial way to the taxpayers. They talk about their studying it and they're going to change it and they're going to change it. Well, the most recent information that I've read is that in 2026, they're going to implement some changes to the multiple bar exam. Where are we going to be then? Are we going to be tied with, the last state, 50? We're already 46 as far as per capita legal services. And I want to submit my letter if I can, because this is a letter that I wrote to the South Dakota Supreme Court 5 years ago. And it was to a different Chief Justice. It was to Chief Justice Gilbertson. And in my letter, and I sent it to the law school, and I sent it to the Board of Bar Examiners, I outlined, number one, that we should go back to the diploma privilege. Number two, I said, if you don't want to adopt that, adopt the Diploma Privilege Plus program, which is you go to law school, you graduate, and then you have an internship and you get your license. That's the Diploma Privilege Plus. I said, if you're going to have some sort of an exam, at least let the people who don't pass it challenge the exam so they know where they screwed up and how to do better. And then I said, add the dean of the law school to the Board of Bar Examiners so there's some interfacing between these entities. We have none. And then I said, lower the score back to where it was and allow them to compensate like every other state except Louisiana, who has essays only. Allow them to compensate. If you get a high score on the written exam portion, allow points to be then flown over to the MBE part. That's what every other state does. That's why they call them compensatory exams and why we're the only state that doesn't have that. And then I said, replace the Indian law question on the bar exam and require a CLE for all of us lawyers who are licensed to go and learn about Indian law so that we would aid us all in understanding the Native Americans. And then I said, if you're going to have a bar exam, well, then at least just have essay questions. That's what I said. It's number 7. Just have essay questions, because those would be questions that would be asked and answered by South Dakota lawyers. And so, it's again, we're going to study it. We're making changes. Things are going to improve. But I'm telling you, here in rural South Dakota, we just have a lawyer shortage. And this is a fix that will protect the public better than any one of these claim changes that might occur in the next 10 years.
Thank you. We'll move on to Mr. Barron. Were you going to offer a very brief rebuttal as well?
Absolutely. Thank you, Mr. Chair.
Heavy on the brief.
Absolutely. I don't think there's been a person in this room that's testified or a person sitting in this room that's taken the new bar exam the way it's been crafted in 2015. And gentlemen, I tell you, it is horrendous. When you have 39% of your graduates passing that exam, and these were top caliber students. They were as good as I've ever seen. Our count is there's been 140 victims of the bar exam. The problem is when somebody fails the bar exam, they don't retake it. They go to another state. They're shamed into not taking it. I have a former student, who immediately sent me, when he found I was involved in this, a copy of the Supreme Court order signed by Chief Justice Jensen, denying him the ability to take the exam for the 4th time. This student, English is not his first language. He's a very bright student, one of the best students at the law school. He passed part of the exam, but not the other. He took it again. He waited so long that he had to take everything again now, and he's been denied permanently the opportunity to retake it. There are many students who have received the same order signed by Chief Justice Jensen that said, you are denied the opportunity to take the exam again. Finally, I just want to say there is an impact. That second-year student was incredibly bright. I have not met him. But there is an impact on the socially disadvantaged. They really, and these are people who work very hard, there is a discriminatory impact on them with the system that we have set up. And these are students who would be law graduates, who would be lawyers that would go to the rural areas and serve those communities. That concludes my remarks.
Thank you. We'll open up to questions of the committee.
Chair.
Representative Goodwin.
This is for Chief Justice, please. Hey, Your Honor, you stated, I think, I wrote it down kind of quickly because I was trying to pay attention, that you thought this was not in our jurisdiction but in yours. And if that's the case, then why haven't you handled it?
Mr. Chair.
Go ahead.
We've been responsive to two different rules hearings requests, and so I'm not sure what you're asking in terms of why we've not been responsive.
Follow up?
Yeah, please. Yes, Your Honor. I'm a layman at this. I mean, I'm not even an attorney. I mean, I don't know. I one time had a bet with John Hansen over here that I could pass the bar exam, but I don't think I want to take that bet. No, it sounds like it's harder than I thought. But so, sir, my question is, would it be possible for you to handle this situation where it doesn't have to come to us to put it in some type of codified law? Is that a fair question?
Mr. Chair.
Go ahead.
Yeah, I guess what I'm saying is this is an area, and we've heard a lot of testimony today about thoughts about whether the bar exam is appropriate to determine competence or whether there's other measures. I'm not going to tell you the bar exam is the only possible method, but we've not been presented a thorough presentation of, here, try this method. Now, Dean Fulton has some thoughts. I'm open to considering other thoughts and suggestions. I'm open to the possibility of putting a group together to study that. But we have not had a comprehensive discussion or request, more importantly, to implement some way to determine competence for individuals other than the current bar exam that we have that's been accepted and is used in 48 states.
Thanks, Your Honor.
Further questions? Representative Gosch.
Thank you, Mr. Chair. You'd mentioned something about 17 people that have failed the bar exam in the last, I don't remember how many years he said, but are there any currently, right now, that or recently have taken it? I mean, where are we at on today's status?
Mr. Chair, what I would tell you is I asked our Secretary of the Board of Bar Examiners to go back and look since 2013, and the number of individuals who requested, and these are USD graduates, only USD graduates, the number of individuals who have requested to take the bar exam and have not been able to pass, and she counted 17 individuals who have not yet passed. Now, some of those individuals, and I would tell you that we recently had a request for a seventh opportunity to retake the bar exam, and we granted it. And so if someone can explain and provide us with an understanding of what they're going to do to study the rules of law and make sure they're able to pass, we're open to considering retakes. But there are, by the count of the Secretary, and of course they're confidential records, I'd be happy to disclose them to the committee, but I'm going to have to go to 17 people and ask them to release that information. I can't do that. I can just tell you the numbers.
Follow up?
Yeah, if I may, Mr. Chair. So we heard testimony earlier that there was 50 some people, but only 33 passed the bar, and so on and so forth. In your recollection, how many of those individuals that are coming to our law school are not from the state? Or, I mean, I would assume that's the reason. Is that an accurate statement?
Yeah, Mr. Chair, and I might defer to Dean Fulton on this in terms of numbers. I know this year they're at about right around 50% non-South Dakota students. I don't know if Mr. Chair, if you're okay with deferring that to
Mr. Fulton,
Dean.
would you like to take a stab at that one?
Mr. Chairman, thank you. Historically, Mr. Chairman, we have been about 75% South Dakota students and 25% out of state. This year, our entering class was closer to 50-50. That was a result of the Board of Regents letting us give in-state tuition to 150 and above LSCT out-of-state students. So we simply recruited 20 more out-of-state students than we've ever gotten, and our goal is to try and convince some of them to stay in South Dakota. But you're right, Representative, that most of those folks that are coming off the top are taking the exam in another jurisdiction for some reason.
So I'll follow up, Mr. Fulton. That can help explain some of the number discrepancy.
It can, Mr. Chairman.
Yes.
It can, Representative. I think one of the things that's difficult when you look at the bar numbers is lots of people collect those. The ABA does not define first-time student in the same way as the South Dakota Board of Bar Examiners. So you just kind of have to get in and look at it. But the biggest reason you're going down from 50 to 33 is folks just not taking the South Dakota exam because they want to be in Nebraska or Minnesota or Colorado or wherever they're going.
Thank you. Further questions of the committee? Representative Gosh, go ahead.
If I may, I'm sorry. He brought that up if they're going to other states. So if we do away with our bar exam, what's that do? We've got to have reciprocity with neighboring states, right? What would that do to that?
Yeah, Mr. Chair, it would make it extremely difficult, what they call portability, moving from state to state. It would make it extremely difficult if you haven't taken a bar exam. There are a number of states will accept the multi-state bar scores and say you can be admitted in this state based upon your passing the bar. So it would make it difficult for individuals to either be licensed in multiple states. For instance, where I came from, the southeast part of the state, a lot of individuals are licensed in Iowa and Nebraska and can transfer those scores back and forth, and you wouldn't be able to do that unless you take the bar exam.
Further questions of the committee? Further questions of the committee? Seeing none, we will close public testimony, move on to committee discussion and or action. Representative Chafee.
Motion to move to the 41st day.
Motion by Representative Chafee, second by Representative Gosh to move House Bill 1073 to the 41st day. Comments on your motion?
Thank you, Mr. Chair. We heard a lot of testimony today about it, and I guess when it kind of boils down to the end of the day, I kind of look at it from the, defer back to the Supreme Court Justice. We had the Dean of School, and we've had the Executive Director. But I always fall back on the advice of my attorney, Jack Heeb, in the past with the compelling testimony.
Further comments on the motion to the 41st day? Representative Hansen.
Thank you very much, Mr. Chair. And I just want to start out by saying how much respect I have for everybody who testified before the committee this morning on this bill. And I'm glad that Professor Barron got a few shout-outs as well. And I share in those thoughts that really, truly, one of the best professors that I've ever had, and I know that the law school has ever had. So grateful for your being here today, Professor Barron and everybody else who testified. The bar exam is brutal. It is a brutal test. And I remember it wasn't that long ago when I graduated and studied for the bar exam, and you don't get much time after law school to rest. You basically start studying immediately after you graduate. And I can't remember how much time there was, maybe 6 weeks or something like that, a month and a half, where you're just studying like 10 or 12 hours a day every day to get ready for that test. And I just imagine going through that process, which I did. I walked out of the bar exam thinking, I didn't know if I passed it or not. I mean, I was just praying to Jesus that I did, because I did not want to have to take that thing again. And I just imagine missing that test by like 1 point and how devastating that is for these people. And it is. And the prospect of sitting down and having to go through all of that study again and then trying to take the test again and maybe even failing it a second time, I mean, it literally is just devastating on your life. And, at the same time, you're trying to make a living, and if you have a young family, you're trying to provide for your family. So I really feel for those people who didn't pass the bar exam. I was fortunate enough to pass it the first time around. Frankly, I trust the University of South Dakota School of Law to look out for the legal profession more than I do some national testing company. I really do. And I think we've got a great school. And I remember back when I graduated, I think every single member of the Supreme Court at the time had not passed the bar exam. And they were some of the most brilliant legal minds that have ever graced the state. One of the lawyers that I practiced with when I was first out of law school, he also was a diploma privileged graduate. And, you know, I got a lot of years left in practice, but I can guarantee you he will be one of the best lawyers that I will have ever known, just all around. So I know that it can work. I do hope that the Supreme Court will take a serious look at this. And I believe Dean Fulton when he says that he's willing to sort of alternative pathways to practice. I'm grateful to the sponsor and the proponents for starting this conversation. But, you know, I see where this bill is headed. And today I'm going to defer to the court. And I just hope that this conversation among the proponents and the court and the law school will continue, because I do think there are some instances where there is an injustice done when really bright people who would make really good lawyers just fail this exam and can't practice law. So with that, I'm going to support this motion.
Mr. Chair.
Representative Goodwin.
Well, after listening to the last speaker, my good friend from Del Rapids, I'm not sure until the very last two words that he was for it or against it. And he kind of talked me into being for it now. I was kind of waving up here, wondering which way to go. But I think in the light of the rural part of our state that's not being serviced, that's what we should look at, is the people and the citizens. And if there's a shortage of attorneys, and this would fix that shortage, I'm going to vote against sending it to the 41st day.
Further comments on the motion to the 41st day? Seeing none, the question before us is moving House Bill 1073 to the 41st day. All those in favor will say aye. All those opposed, nay. Secretary, please call the roll.
Representatives Anderson.
Aye.
Beal.
Nay.
Chafee.
Aye.
Goodwin.
Nay.
Gosh. Hanson.
Aye.
Jensen.
Aye.
Lesmeister. Aye. Reimer excuse Smith.
Aye.
Weesey.
No.
Johnson.
No.
Peterson.
Aye.
8 ayes, 4 nays, 1 excused.
Motion carries. House Bill 1073 will be sent to the 41st day.